be a good idea for us to familiarize the folks that watch our videos with just the overall anatomy of a trust and will litigated case in California. And we've broken this down into steps over the years, and we try to do these steps as quickly as possible. Quickly doesn't mean haphazardly or in a lazy manner. It just means we want to walk through these steps quickly when we have a trust litigation matter come into our firm. And so, for example, if we have a potential trust contest that's coming in the firm, the first step obviously is somebody calling us and saying, can you help us? And you're generally asking them for a copy of the trust. So the first step would be to get a copy of the trust and to look at the trust to determine what are the individual's rights. So maybe you could walk us through why it's so important to get a copy of the trust. What are you looking for, Keith, when you're speaking to somebody on the phone and they provide you a copy of the trust to figure out if this is a case that's worthy of a trust contest in California?
The first thing that I want to see is what is the document that disinherits you? And then what does the previous document look like? So if there's an amendment that was going to leave you a share of the estate, let's say there's 3 kids, you were going to get 1/3. And then there's a new amendment that says everything's going to one child and you're completely cut out. We need to see that progression. So before you were going to get 1/3, now you're getting nothing. That's what we want to see. And the reason we want to see that is if you're disinherited under this amendment, but if you go back to the earlier document, you're disinherited there too. And then there's an earlier amendment where you're disinherited too. That becomes a much more difficult case, maybe even an impossible case. So we want to see if we put in all the work and effort to overturn this trust amendment or this document, what would it roll back to? Because it's going to roll back to the earlier version of the trust and the amendments that were in place before this latest one. So that's what we're looking for. And the other thing we tend to like is we want to know how far back in time this amendment that we don't like, when was it created? So the further back in time you have to go, the more difficult these cases become, which I always tell people it's kind of funny because that's not one of the legal elements. You can look at the statute for undue influence and nowhere in there is it going to say, ask you how long ago was this amendment created. But it certainly comes in when it's one of the persuasive elements. So when you go before a judge and you're trying to convince somebody you should overturn this, it becomes much more difficult if the amendment we don't like was created in 2007 versus if it was created in 2017 versus if it was created in 2021 and then the parent died in 2022. So all of those factors come into play, but primarily we want to see what were you going to get, what are you now supposedly getting, and we try to figure out, can we attack that amendment for you and overturn it and invalidate it? That's what a trust contest is all about. So
let me ask you, if I was a potential client and I called you and I said, hey, my mom and dad had a trust, there's 3 of us, and the trust was created in 2007, and it gives everything equally to my brother, sister, and myself. And my mom and dad both died within a year of each other a year ago, about a year and a half ago, somewhere in there. Mom and dad have passed away. And I just found out, I got this thing called statutory notice, and it told me that there's an amendment that was created in 2020. And in 2020, it gives everything to my sister and excludes me and my brother. And of course, my sister was living with my mom at the time. And I didn't, we thought she was there to take care of mom and help mom along. Is that a good case, or is that something that would pique your interest?
It's sounding favorable so far. So you have an amendment that wasn't done that far in time. It was done by mom when she was living with sister. Mom was already suffering, it sounds like, some medical ailments. The next question I'm going to want to know is, let's look at the date of the amendment. And if it was done, let's say it was done, February 1st of 2020. What was mom's condition around that time? Dementia? Did she have dementia, Alzheimer's, any signs of stroke? What was her age? What was her illnesses, if she was suffering from an illness? These are all factors that go to whether or not somebody is susceptible to undue influence. And that's the first step in an undue influence case. So I'm always looking at what was the condition of the parent around the time the amendment was created, because that's going to drive whether or not it sounds like a promising case. Of course, there's a lot that you have to do to gather evidence to prove that, But if somebody says, oh, mom was fine, she no Alzheimer's, dementia, no strokes, no health ailments, she was fit as a fiddle, and she signed this, then you're thinking, that's not as good, versus mom was suffering from cancer. She was on a lot of medications. She'd been diagnosed with dementia 3 years before. She had her good days or bad days. Now it's starting to sound like a more promising undue influence case, because that sounds like somebody who is most definitely susceptible.
So it sounds like to me, the first step here that we've been discussing is simply getting a copy of all of the estate planning documents so you can see the full picture of the intent of mom and dad or whoever created the trust during a period of years. And that will help you with your analysis to determine if it's a case worthy of moving forward on. Is that accurate?
That's correct. Yeah. Is this a potentially viable case? Does it sound like the type of case that we would want to file and find out more information and discovery?
Okay. All right. We've got our first step down. And so then that naturally leads to a second step. Let's say that we have a case that is worthy of coming in. We see facts that support the idea of a trust contest, facts that lead us to believe that this was not what the mom or dad wanted to do with their assets when they died, and there was an exercise of undue influence over them by somebody. So now what we need to do is we take this over to the litigation side of things, and we do what we call a trust breakdown. So we go through the trust, every single page, every single document. You've often said that every word, every phrase, every sentence in a trust matters. Why do you say that?
Because every term in a trust is there for a reason. And so when you're first starting to learn trust, if you keep that in mind, it helps, because you can think to yourself, why is this here? If it's here for a reason, what is it doing? What is it supposed to be doing? And some trusts are very simple to read, and other trusts are very complex to read. But all of them have a certain common denominator. And that is that at some point in time, the assets will be distributed. And so if you could figure out how are these assets supposed to be distributed ultimately when everything's said and done, then at least you can understand the path that the assets are supposed to flow through. And that goes a long way towards figuring out what you're trying to accomplish.
So let's say you have a trust in front of you and you're doing that trust breakdown, Keith. What I'm a first year lawyer and I come to you and I say, I don't know what I'm doing here. What are some of the things that you look for as you're going through that trust document, in addition to looking at every single page and wondering why certain terms or certain ways? What are the things that you're really looking for as you're going through there?
First, if it's a married couple, the first thing I'm looking for is, does the trust split after the first spouse dies? Because a lot of them do, but quite a few of them don't. And so oftentimes when one spouse dies, the trust will mandate a division of assets between the survivor's trust and the bypass trust, for example. Half of the assets are revocable, can still be changed, amended. The other half are put away in an irrevocable trust. That's what a bypass trust is. And that's important because once one spouse dies, if a portion of the assets become irrevocable, then the survivor can't do an amendment and change it. Whereas if the trust remains revocable for the whole trust, even after the first spouse dies, and it can be amended and changed any old way that the survivor wants to, then that's a different analysis you have to go through. So I'm always wondering, what portion of this trust became irrevocable, if any, and when did that occur? Was it at first death or was it at second death? Some trusts don't do that. One spouse dies, everything stays revocable, and then the second spouse dies. And then the next question is, once both spouses are dead, or if this is a trust for a single person, the next question is, how are the assets distributed after the settlor dies? And there's any number of ways that can happen. There's specific gifts, there's continuing trust for children. There's all sorts of different provisions that you can find. So I want to try to figure out who gets what and what are the terms that they get it. And in particular, I want to know, is somebody getting their assets outright? So you're entitled to $1 million, here it is, it's yours. Or is your share being held in some sort of trust where you only have the right to income or principal distributions if you need it for your support or something like that? And that's the biggest distinction. So I want to understand how the assets are passing out. And then once I kind of map out the distribution of the trust and who's getting and how they're going to get their assets, then I usually like to go and look at who are the trustees. So who's responsible for all this? Because somebody has to figure all this out. They have to allocate assets the way they're supposed to go. They have to make distributions. who's responsible for doing that, and what's the succession line of trustees. So those are usually the two most important things that I look at. And then on an amendment case, if you're dealing with an amendment, I want to know what power did the settlor or the surviving spouse, if it's married couple, what power did they have to amend the trust? And, could they amend it? Could they not amend it? If they did amend it, what were the terms? How did they have to go about amending it? And you just want to double check those type of provisions. So those are the highlights. Those are the things that I focus on first, and before I worry about any of the other trust provisions.
Okay, so we're kind of at step 2 here. Step 1 was simply getting copies of the trust, going through it, understanding the facts of the case. Now we do the trust breakdown and say that we do see that there are 2 possible claims that we can make. One is a trust contest claim, and the other is a civil claim for financial elder abuse. So that's where we tend to look at, drafting up a petition to file in the probate court to ask the probate court to make a determination about whether an amendment or some trust instrument is valid or invalid. And if we're bringing a trust contest, we're trying to invalidate something. So why don't you walk us through just briefly, once we have that petition drafted up, what does that look like? What are we trying to do with those 2 primary claims? What are we really wanting as a goal at the end of the case?
Well, all of this our main primary goal is to get our clients their share of the inheritance, or as much of their share of the inheritance as we can. And so you have to draw up the petition and file it to start the lawsuit. And then you have to start gathering evidence. Trust contest cases are probably the single most difficult cases in the area of trust law that you can do, because the person contesting has the burden of proof. You have to present evidence. That evidence is not easy to find. And undue influence is almost always having to be proven by circumstantial evidence, because the primary witness who could tell us if they were undue influenced or not is the decedent, and they're gone. And so we don't have access to them. And so you have to prove your case by a lot of circumstantial evidence, and that makes it a little bit more difficult. But that doesn't mean that you can't get something out of the case. And so it's a matter of working the case, building the evidence, taking good depositions, and bringing all of the evidence together. And ultimately, you probably are going to get a very favorable settlement if you work the case correctly. But what is your experience in terms of talking to judges about trust contest cases?
Well, I think that it matters how the cases are worked up, because when you're giving those statistics, that's based on lawyers in general, and so if you have a lawyer that's worth their weight and they do the hard work, that brings significant value to these kind of cases. But I don't disagree with you; they're very difficult cases. You do carry the burden of proof through the entire case, and judges generally don't like to go against a decedent's intent if you can't prove that was not the decedent's intent. And so you're going to have to show some pretty compelling evidence. It is based on the preponderance of the evidence. It's the lowest civil standard there is. But still, you're going to have to persuade a judge that something just wrong happened here. And because that wrong thing happened, the settlor, the person who creates the trust, their intent was defeated. It was taken away. It was usurped by someone else, and they took advantage of that individual. And so when we do like to talk to judges as much as we can, when we are talking to judges that are currently on the bench, anytime we go to their chambers, which hasn't been a lot during COVID, but before COVID, when we had a chance to go into their chambers, we would talk to them about how did they view trust contests, generally speaking, and what evidence were they looking for. We want to bend their ear. We want to find out what makes them move, what makes them get interested in a trust contest case. But many of them said, sometimes the lawyering, I shouldn't say sometimes, in many cases, the lawyering wasn't very good, that they're not persuaded because of that. And then in just other cases, unless you have something that you can really give them to bite into, they're not going to do it. And you make a great point, Keith, in that you're generally looking at the totality of the circumstances, which is circumstantial evidence. There's rarely direct evidence of undue influence, and that makes sense. People that go around and exercise undue influence over people don't write down on a piece of paper, I'm hereby unduly influencing Keith Davidson today to create a trust that will benefit me. It would be great if people did that, but they don't. So what you have to look to is text messages are great. Social media at times can come into this. Emails are wonderful. What information was given to the estate planning attorney? Is this a new estate planning attorney as opposed to the family attorney that's been doing the trust for years? Is this done in a hospital setting? Is this done with just a few days left for the decedent to live? All of these things come into it and can be helpful, and that's what judges are looking for. And if you look at the statute for undue influence, sorry, I got a fly that wants to join our Zoom here. If you look at the statute's very clear on the types of things that judges are going to be interested in. Age, illness, what was the person who did the exercise of undue influence, what position were they in to this person, and what were the things they did to help create this trust. If they just drove their mom or dad to a lawyer's office, that's generally not going to be enough. But if they drove them there, sat in the meetings, sent multiple emails to the lawyer on, no, you didn't get it right, you need to change this or that, which we see that in many cases. Now a judge is willing to listen to that. So yes, again, these are tough cases. Yes, we're drafting the petition with care. We want to make sure that the petition is drafted well, no spelling errors, that we're making good, solid claims, that we have enough facts so that if somebody brings a demur, we can overcome the demur. And we're going to include the trust contest based on undue influence. We might throw capacity in. That's for another day to discuss. And then, of course, we want to include financial elder abuse. Financial elder abuse is a fantastic claim to bring for a plaintiff or a petitioner in probate court, because if you are successful in that claim, you're going to get the compensatory damages that you prove up at the time of trial, but you're also going to likely get your attorney's fees, which is significant, right? You don't get attorney's fees generally in these types of cases. Mm-hmm. And then you're going to get punitive damages if you can prove those up. So it's a very nice statute. It's something that we should use more often as people bring in cases on behalf of beneficiaries who have been wrongfully handled or have been basically lost their inheritance due to the acts of somebody else. So step one, again, we talked about was getting your hands on the trust so you can have an understanding of what's going on. Step two is doing that trust breakdown and drafting up a petition and filing it with the probate court. And now we're going to get to step three. And step three is, once that petition is filed, there's a short window of discovery hold, we call it. You can't do written discovery or any type of discovery for that matter. But now we're going to get into discovery. And this is where you spend most of the life of the case, is doing discovery. So can you walk us through your thoughts on written discovery and ultimately depositions in a case like this?
So let's start with an overview of written discovery. What are we talking about? What's the overall purpose of it? And we talked already about the need for evidence. We have to prove our case. It's probably going to be circumstantial evidence, not direct evidence. But what is evidence? And really, evidence just comes down to three things, right? It's the facts, the witnesses, and the documents. And so we're looking for all of that information. And usually facts are brought into trial through witnesses and documents, but that becomes the evidence that we need. So you can think of, we either need to talk to witnesses or we need to find documents. And that's what written discovery is all about, is locating that information. And with regard to documents, actually obtaining it, getting copies of it. Let's separate out depositions from written discovery for a minute and focus only on the written discovery. We know that there's a pool of information that we must get and it's universal almost in every single trust contest case. So what's the number one source of documents you're looking for in a trust contest case, Stewart, when you're doing written discovery?
Well, you're looking for documents from third parties, and you're looking for documents from the party themselves, the bad actor. And so we generally like to move out on the third parties rather quickly. And so if it's, the decedent was 91 and suffered from dementia and Alzheimer's, we're going to want those medical records as soon as possible. And so we're going to find out who their treating physician was. A lot of times they end up going to the emergency room right there in that last year of life. And so you're going to want to make sure you get the emergency room records. You're going to want any hospitalization records, any hospice records. Hospice records are fantastic. And then just end of life records. If they spend the last 2 weeks in the hospital and that's when the amendment is created, it would be important to get all of those documents.
So
another treasure, go ahead.
So quick question. So number one category of documents we must get is medical records, because we already said one of the elements is you have to prove somebody's susceptible to undue influence. That's done through medical evidence. What do you do if you don't know who the elder's doctor was? How are you going to find out the information so you know who to issue a subpoena to?
And that comes, it's a little slower process, but it just comes back to issuing written discovery to the party in the case and finding out who were their physicians. And once you find one or two physicians, it's nice to find two, because then they start relating back in the medical records to other providers, medical providers. Then you can get all them, and then you get another medical provider. And before you know it, once you have 3 or 4 medical providers, you now have a universe of medical providers, and you can get all of those records. And all of those records are important. So you want to get those. If you have to send out written discovery, or even take the deposition of the bad actor to find out who were the doctors of this individual, then that's what you do. So most of the time, though, the people we represent, the siblings, they generally have a good idea of at least who the treating physician was. Maybe they took mom or dad to that physician several times. So generally speaking, we can find that out. There is a case every now and then, though, where somebody doesn't know who the doctors, the medical providers were, and you got to go through that slower route, but you ultimately still need to get those medical records. The next area that is super important to get right away is the drafting attorney's file and the entire file. The evidence code actually has an exception for the attorney-client privilege for estate planning files of estate planning lawyers after somebody has passed away. And so a lot of times these drafting lawyers, they're not litigators, and so they're a little nervous, and they refuse to provide us with the documents after we've subpoenaed them. And so then we just do a short motion to the court, never been denied one time, and the court orders them to turn their records over. They feel safer that way. The records get turned over to us. And then, of course, we ultimately want to take that person's deposition. I know we're talking about that in a separate section, but you got to get those drafting attorney records. There is a treasure trove there. You either find no work was done, no due diligence of any kind was done, and for $700 or $800, this person transferred millions and millions of dollars of wealth away from 2 of the siblings to give it all to one, with doing no inquiry whatsoever. We find that more often than not. We wish we didn't find that, but we do find that more often than not. And then there's other times where you'll find a really well put together set of notes. But in those notes, generally lawyers that are worth their weight and are taking the time to actually document the process, they put down what you and I call red flags. And they don't call them red flags, but anytime they come across concern, they jot it down in their notes, because that's what good lawyers do. Good lawyers take a comprehensive history of this person before they draft the estate planning documents. And so while the estate planning attorney is not under the gun to put their client in front of a hot lamp and put them on a lie detector test and beat them up and take them to doctors and make sure that they have the ability to create this estate plan, they at least should have a good history that they can replicate with notes, write down anything that concerned them, write down anything that the decedent said to them that helped them better understand whether there was an exercise of undue influence taking place or the absence of that, whether this person had capacity in their opinion for the hour and a half they met with them. That's the other thing we see is we see estate planning attorneys meeting for 5 minutes with somebody, and you really can't get a gauge of that. So that estate planning file is super important. Get the whole thing, spend a lot of time going through it, get all the medical records, which we previously talked about. Read the medical records yourself, Keith. They've got these services that you can send the medical records to, and they'll put together medical summaries for you. That's a huge mistake. You just get those medical records in PDF, and you sit there and you get your popcorn or whatever it is that makes you happy, and you spend hour after hour going through them, because that's how you really get to know the decedent, is through those. And then there's one final category of documents. I'll let you talk about that, but we want to get this from the third party. And what is that final category of documents?
It'd be financial documents. And so look, at the end of the day, what we're going after here is assets that belong to a trust. That's money, real estate, stocks and bonds, brokerage firms. You need to get those records because you need to understand what is the universe of assets in this trust. And a lot of times, especially when you're dealing with older parents from the older generations, those people don't like to talk about what they have a lot of times. And so you'll meet a child after the parents have passed on, and you'll ask them, well, what assets did your parents have? And they'll say, well, I don't know. My mom or my dad, they didn't talk about that sort of thing, and I didn't feel comfortable asking them. And naturally, why would you? I mean, you're not supposed to grill your parent about their finances. So a lot of times people think they know what their parents have, but they're incorrect, or they simply have no idea. So we need to issue subpoenas to the banks that hold trust assets, any brokerage accounts. If assets have been sold, we want to issue a subpoena to any escrow companies to the extent we know who they are, so we can get the sales records. If there's property management companies, we need subpoenas out to that. We might need to subpoena the CPA, the accountant who might have done trust tax returns to find out what's going on there. So there's a lot of records that you're going to want to get a hold of to figure out the value of this estate. And this brings us back to the point of, well, what if you don't know, just like the medical provider, what if you don't know what banks or brokerage accounts the parents had? And so if you think about this, if you want to issue a subpoena, you first have to know what entity you're going to issue it to. And you don't want to just issue subpoenas willy-nilly. You want to issue it to the people who are most likely going to have records. So if you don't know, you first have to send a set of interrogatories to the other party asking them that question. Please state the name of all banks, that hold trust assets. And then they'll respond to that, and hopefully they respond to it properly. And then once you get that, then you can turn around and issue a subpoena. So this all takes time. It's not like you're going to get documents quickly when you issue subpoenas, but you will get them. You just have to be patient, and you have to keep pushing on these entities to provide them. Because another thing that will happen with these financial subpoenas when you're subpoenaing banks and brokerage firms is they won't always respond to you. And so they have a set amount of time. They have 20 days after you serve the subpoena to give you the records, and they won't. And sometimes they'll contact you and say, hey, we're running behind, we need more time. And sometimes they won't contact you at all. They'll just be radio silent. And it's up to you to have to contact them. Well, imagine, if you have to call up Wells Fargo, that's not easy because it's a massive bank. There's all sorts of departments. Nobody wants to talk to you about your silly subpoena. That's the way they view it. And so you have to find the right department so that you can talk to these people and you can get the right person on the line to see who's handling your subpoena and when are you going to get your documents. But it all can be done. You just have to persevere and have a certain amount of resilience to keep going. But it does take time. So that's my one warning about discovery and subpoenas and all that sort of thing. It's going to take a few months, quite a few months, in fact, to actually gather this information together. But really, in my mind, those are definitely the three primary areas you must subpoena and get documents. So medical records, drafting attorneys, and financial. Those are the big three that you're going after.
The one other area that we don't talk about so much because we just do it naturally is we want to go ahead and pull deeds, which are easy enough to get because they're public records. And then we look at Zillow and Redfin just to get an idea of residential property. If it's commercial property, we're going to have to get appraisals, or we're going to have to demand any appraisals into the discovery from the bad actor if there are any appraisals out there. Many times when someone passes away, there's an appraisal done for estate tax purposes or whatever the case may be. And so we want to get all the appraisals. If a property has sold, like you said, we want all the escrow documents to see, was it an arm's length transaction? Was this a bona fide purchaser who came in and got this? Was this something that was, or was this a sweetheart deal for one of the trustees' friends at a reduced amount, or maybe to the trustee themselves? We see that from time to time as well. So that kind of completes the written discovery side of things with subpoenas and sending out written discovery to the party. Of course, the depositions we're going to want to do is the drafting attorney. We'll want to do the treating physician in many cases, any treating physician. So a lot of times older people have 4 or 5 physicians that are involved in their end of life care. And so we're going to want to probably take all of those depositions if required. Then we don't necessarily need to take the bank tellers or the financial institutions depositions. There, the documents are more important. Although from time to time, somebody will have said that some, banker overheard the conversation, and we got to get them in and figure out what did they overhear, or do they recall anything? And many times they don't recall anything, but we need to find that out as well. So that would be the depositions, and depositions, they're the most important part of the case, in my opinion. That's where all this hard work from steps 1, 2, and 3 come to fruition. And we finally get that day with the bad actor to sit down and go through what they have to tell us about this case. And generally speaking, in all depositions, you're really looking for the ability to find out answers that you don't have. So you have ideas, you have your gut telling you that there's certain things going on. So here's your opportunity to ask about those things that you're not quite sure on, so you can get answers from the individual or individuals that you need to understand better what's going on. And then once you've done that, and by the way, that's a big block of the deposition. My favorite part of the deposition comes up, and that's where you're looking to collect admissions. You want to get people to agree with your side of the case, to the elements that you're trying to prove at the time of prison, of trial. Trial is like prison at times. And what are these admissions you're looking for? They generally start with, you agree with me that your mother had dementia. You agree with me that your mother was suffering from Alzheimer's disease. You agree with me that your mother had her driver's license pulled 3 years before she changed her amendment. And these are just admissions. And these are things we know about the case already. We just want to get the other side to have to admit or deny those in deposition. If they deny them, we're going to ask them what's their basis for denying them. And we have the opportunity to find out additional information. And that's why depositions are so fantastic, is that we are able to punch and counterpunch with the person we're asking questions. Whereas when we're doing written discovery and you're sending over questions to this individual to answer, their lawyers helping them. Now, the lawyer's not inappropriately helping them, but lawyers are appropriately helping them. In a deposition, you've got that person right in front of you, and they've got to answer your questions. And then, Keith, there's one last thing that we like to do in depositions, and that's simply lock them into their story. Because when we're at trial a year from now, we don't want to be surprised by a set of facts, a fact that we weren't aware of, or witness that we weren't aware of, or a document that we weren't aware of. And so this is our opportunity to exhaust them on, we had one lawyer tell us he likes to vacuum clean people. This is where you're locking them into their story, making sure you know everything so that there are no surprises for you at the time of trial. Because if you've asked them, have you now told me everything about this event that happened on Christmas in 1994? Yes, I've now told you everything. And then at the time of trial, they come and bring all kinds of new facts that happened ostensibly at that Christmas issue. You can pull up their deposition transcript and show, no, that they're not being honest with the court, honest with the trial, and you can impeach them with that deposition transcript. So finding out facts that you're not sure of, collecting admissions, the funnest part of a deposition, and locking them into their story, that's what you're really trying to do in a deposition with every single witness. With the person who's the bad actor, you're being a little bit more firm with them and a little bit more direct. If it's somebody that is a third party, that's just a nice person that oversaw something, obviously you're just trying to figure out, what did you see, what did you hear, what do you recall, and then lock them into that so that you know what they're going to say at the time of trial. I don't know, do you have anything else that you add for depositions, Keith?
No, I think those are the three primary objectives. And it's really important to just stop for a minute for people who aren't familiar with depositions, haven't experienced it before, and really understand how important those three things are. You know, asking questions just because you want to know what this witness is going to tell you is important. Getting admissions from them that they can agree on is important, or not agree on, and finding out why is important. And then locking them into the story, it's also important. This is where a lot of times people who aren't familiar with depositions will say, well, I don't know why you're taking my brother's deposition. All they're going to do is lie. They're big liars, and they're just going to lie to you. So what's the point? Well, let's slow down and take a step back here. If you have somebody who's lying, you want to lock them into their story. You want to lock them into their lies, because you're going to be able to prove that they're lying by other evidence come time of trial. So just because somebody's a liar doesn't mean you shouldn't depose them. In fact, those are the people you really do want to depose, maybe even more than others, because you can lock them into their lies. And once you have it in deposition, they can't change their lie to something else. And they may not even remember their lie come time of trial. And so those are the witnesses that are just a complete mess at trial for the other side, because they say something totally different at trial than they said at deposition. And that's the beauty of taking a deposition. But some of the biggest objections I hear from people who aren't familiar with depositions is, well, they're just going to lie, so what's the point? Or they don't really know anything. So what do you think about, well, why are you taking that person's deposition, my brother's deposition, who brought this lawsuit? They weren't even around. They don't even know anything.
Well, you don't want any surprises at the time of trial. And so if you have the opportunity to take someone's deposition that you think has something to add to the case that could be adverse to your client and your client's claims, you want to know those things so you can study them and understand them better prior to trial. You don't want to have them show up the day of trial and hit you with a curveball that, there's 5 other trust documents that were signed 15 years earlier that give everything away from your client as well. So those are issues you want to address right away. One other category of depositions that you and I enjoy thoroughly are expert depositions. And basically, expert depositions are we're going to be taking the expert that's going to be opposing us at the time of trial, and then the opposing lawyer is going to be taking our expert. And so why do we enjoy taking the expert depositions in these cases?
Well, let's talk about who these experts are. So the number one expert in every single trust contest case is going to be your medical expert. So we said at the top that you have to prove for undue influence, you have to prove that somebody is susceptible to undue influence. That requires medical evidence, and most medical records cannot come into at time of trial because most of them are hearsay. So the way that you get around the hearsay problem is you hire a medical expert to review the records and then come in and give an opinion. And that expert is going to opine on whether or not, in their opinion, after reviewing the medical records, whether this person is susceptible to undue influence. So we're going to hire a doctor, the other side's going to hire a doctor. Our expert's going to say this person was susceptible to undue influence. The other side's doctor is going to say this person was not susceptible to undue influence, or is a much lower susceptibility. Ours is going to be much higher susceptibility. So the whole idea of deposing an expert is once again trying to lock them into what exactly is your opinion here, and more importantly, what did you review? What are the underlying facts that you're looking at? And you're not going to turn the other side's expert, most likely, in most depositions. You're not going to force the other side's experts to agree with you or to agree with your expert. But there's areas where you can undermine their opinion come time of trial. And so it's really important here again, just like with all depositions, depositions are a device we use to prepare for trial in large part. There's a secondary use for depositions, which is to expose to the other side the weaknesses of their case. That works, that serves that purpose as well. But when you're deposing an expert, you need to understand what are their opinions, and then separately, what are they basing it on? And what facts are they, what did they even review? What facts are they even looking at? And because if they formed opinions without looking at all of the available facts, now you have something to talk about come time of trial. So that's my view of it. How would you describe it, Stewart?
Well, the reason I enjoy taking expert depos is because you're taking somebody's deposition that has 30 years, sometimes 40 years experience in a certain discipline. And who are we? We're just lawyers. I mean, we have discipline as being lawyers. We've been doing this for a lot of years, but you have to learn a subject matter. And because we do the same case over and over again, pretty much in our practice, or the same type of cases, I should say, we've learned this over the years, but that's not 40 years of practice like a neurologist or a psychiatrist or something like that would have. Plus, these people are experts for a living, and so they get much better every deposition they go to. So they've taken a lot of depositions, and so they're very good at doing this. So there's 2 areas that I like to focus in on with these doctors when I'm taking their deposition. And the first is, what did they actually review to formulate their opinions? And the reason that's an important question is because experts are really expensive. It's not unheard of to hear experts charging $800 an hour for the time they spend reviewing medical records. And so if the medical records are, look at my hands here, are this thick in the case, generally the other side's going to cherry pick some records and get them over to the expert and not give them, $50,000 worth of records they're going to be billed for to go through. And so you can almost count on that in most cases, not all cases, but in most cases. And when I see that the doctor was not given anything, I want to ask the doctor, did you review these documents? Yes. Did you ask for anything else? And universally, no, they don't ask for anything else. So that's the record. And when I see that, I know that they don't know a good history of this person. So then I just turn into Jeopardy and I start asking these people, well, how many kids did this person have? And what were the names of the kids? And how often did they come see you as a doctor? And what other doctors did they have? What other ailments did they have? What were you seeing them for? I mean, many times they haven't even looked at the records. So it is because the lawyers that hire them don't want to pay a lot and tell them, hey, I don't want to pay you a lot. So these are really fun depositions. I'm not going to challenge this person on the distinction between Lewy body dementia and Parkinson's disease dementia, because they're going to blow me out of the water. But I certainly can look at what they wrote down time and time again about hallucinations, about pulling somebody's driver's license 3 or 4 years before they pass away. Those are things I can look at, and I can undermine the expert who's also ostensibly looked at these records. And of course, when you find the driver's license being pulled 3 or 4 years before the decedent died, and the expert didn't review those records, oh, that's an even better day, because now you would have liked to have those records before you formed your opinions in this case, because you've already formed those opinions, haven't you? And you haven't looked at this medical record, have you? So that's a really nice thing. So with our experts, we bite down on our tongue really hard, and we give them all the medical records, and we say, review everything, because we want them to have a thorough understanding of what's going on. And when they're being cross-examined by the other side, we want them to be able to say, I reviewed it. I reviewed everything. The other thing we ask our experts is, if there's anything else you need or think you need, I want you to ask me for it. And routinely, I'll get an email from an expert, which emails are discoverable to the other side. Hey, do you know if there's any of this out there? And sometimes there is, and I say, yep, I'll get it for you, and I send it over, or I say, I'm not aware of anything. But it's just nice to know that our experts are given everything that they ask for, even though they charge a lot for this stuff, so that when we're going against the other experts, they generally aren't in the same boat. So expert depositions are important. Party depositions are extremely important, maybe more important than the experts. And then, of course, you got third parties, and they can even be some of the best depositions you will ever take, because judges tend to believe people that don't have a dog in the hunt. They don't believe parties for the most part, because if a party's testifying, it's generally to benefit themselves. The experts, they understand the experts are going to offset each other to some degree. And so if there is third parties that don't have a dog in the hunt, the bank teller that overheard a conversation, the handyman, we had a handyman once that came in and sat down at the kitchen to eat his lunch, and he overheard a lot of important things about a case, and he testified to those a few years later very strongly, and the case settled right after the deposition to our client's favor, because this individual was so credible and had heard something that was so good for our case and supported our case. And so those are the kind of things you're looking for in depositions. And of course, to lock everybody into the story so that there are no surprises. And so it sounds like what we've done, Keith, when we're looking at the anatomy of a trust litigation case, in this case, a trust contest, we've gotten you the trust document, we've done a trust breakdown, we've looked at the legal theories, we filed a petition in the probate court, we've done a host of written discovery, several sets, we've subpoenaed all the important documents, and we've taken every important deposition that we can think of. What's the next step?
Well, the next step most likely is you're heading to a settlement conference or a mediation.
What before you describe what a settlement conference or a mediation is, they're kind of one and the same, but why after depositions does it naturally lead to a mediation in these cases?
Primarily because if you've taken a good deposition, you've exposed the weaknesses of the case to the other side. And you've shown that they may not enjoy going through trial as much as they thought they would. They also may not have as strong of a position as they thought they did. Everything seems very good in your case until you get to depositions. And that's when things shift, or can shift substantially. Sometimes they shift substantially in your favor. Sometimes they shift away from you. But the point is that depositions, it's kind of like shining a bright light on the case for the first time is in depositions. And that's really when the magic happens and people start seeing just how good or how bad their case really is. And so that's usually the point in time when somebody will say, hey, Stewart, would your client consider mediating, going to a mediation? Now, every single time somebody asks us, is your client interested in going to mediation? Of course, we're going to talk to our client, but we're always happy to go to mediations because there's no downside to them. Number one, you're going to either have a chance to settle your case on favorable terms or not. It's voluntary. You don't have to accept the results of mediation. You're either going to broker a deal or you're not, and you're going to walk away. No harm. Also, you tend to find out information in mediation, so you can actually use it as a discovery device. So you really should think of mediation as yet another discovery device. And the third reason you want to go to mediation is because chances are the court is not going to be very excited about setting your case for trial if you haven't at least mediated. You have to check that box, because most judges want to see that you at least tried to settle the case before they're going to set you up for a trial. And so in this area, you tend to have two choices. You can go to a mediation, which is a service that's provided usually by a retired judge. Everybody pays a little bit of money. You go and you spend a day with this retired judge. You're in separate rooms, although now we're in separate Zoom rooms even, because it's usually remote. And the judge just goes back and forth and tries to broker a deal. Or you can do what they call mandatory settlement conferences. So a mandatory settlement conference usually takes place at the courthouse. You go there, there's a judge, usually sometimes a retired judge, sometimes an attorney, sometimes an actual active serving judge, and will act as kind of a mediator. And so they'll talk to the parties and they'll try to broker a deal. The problem really with mandatory settlement conferences is they're not as good as mediations. With a mediation, you get one dedicated person who's paying attention to your case for the whole day. With mandatory settlement conferences, they're usually juggling multiple cases that they're trying to settle all at the same time. And there's not as much of an incentive for the person at the courthouse to settle your case. They'll settle it, they won't, it doesn't matter. Whereas with mediators, they really take pride in settling cases. They love to talk about, I've got a 92% settle rate or something, whatever their numbers are. So it's bragging rights, but it's also how they get their business. I mean, a good mediator who settles cases will get more business. And so it matters to them that they want to settle your case. So most cases are going to head to a mediation, and that's a perfectly fine thing to do. We highly recommend mediations for almost everybody in any phase of litigation, but it tends to work best after the depositions are done. So how do you approach a mediation, Stewart? What are you really thinking about as you're heading into a mediation in terms of what you want to accomplish?
Well, I can't agree with you more that you do have nothing to lose by going to a mediation. It does not show weakness, in my opinion, at all, because of course you're always willing to go to trial. And you're either going to get a hopeful, favorable settlement, which is fantastic, or even better, Keith, you're going to get the very best arguments the other side has. And you're going to get them articulated to you by a very bright judge who has done this for many years and is now a retired judge doing full-time mediation. The other side is going to give you their best arguments as to why you lose. And so now you've got those to focus on as you're getting ready to go to trial. And so the good news is that probably 80%, maybe 85% of mediations result in a successful settlement for the parties. And it is a successful settlement for everybody, because everybody gets to move on from the litigation cycle, the litigation nightmare. It's not fun. Even if you have good lawyers, litigation is stressful, it's expensive. I was going to say the other reason mediations come up after depositions, that's generally after everyone's paid several $100,000 in attorney's fees and they're done paying the lawyers and they want something to resolve. And so you got a good chance to do that at mediation. My theory on mediation, it used to be to make a really nice brief for the mediator, and we still do nice briefs for our mediators. But what we do is we give the mediators the best ammunition we have. We don't want to hold back. We want to put our best arguments and why we win this case forward to our mediator. And then the mediator, if we can properly bring them up to speed on the case as we see it, these are very bright people, have been doing this for more years than you and I combined. They go to the other side and they hammer them and they make them feel about this tall. What we always tell our clients is the mediator is going to come back to our side and they're going to hammer you and make you feel this tall too, because they're going to take the best arguments from the other side. So you've got a very skilled individual going back and forth between rooms, changing hats every single time they come into the room, telling you, your client, you've got a horrible case, going to the other side, telling them they have a horrible case. And then as the day progresses on, generally both sides become a little bit more reasonable. Offers and counteroffers are going back and forth. People are feeling each other out. Again, most of the lawyers know each other really well at this point in time because they've been litigating the case for a year to 2 years, sometimes 3 years at this point. The parties obviously know each other from either growing up with one another or being family members in some capacity. And so ultimately, they're generally 80–85% of the time, there is a sort of final settlement that everybody can live with and everybody moves on. For those cases that don't settle, and there's a handful that don't, sometimes a second mediation will do it. That's usually a few months later when we've got more expert depositions taken. That's putting more light on the facts of this case, and everybody has a better understanding at that point in time, and also more money will have been spent. And then if we still can't settle, there's one last step that we do in these cases. We're not going to get into motions for summary judgment or motions for summary adjudication. Those do happen from time to time in these cases. They're not that successful just because these cases aren't built for them. We can talk about those in another video, but generally if we can't solve this case at a mediation, where are we headed to now?
We're going off to the big show. That's trial. And so that's where it all is. That's the boxing ring that you have to get into, and you have to duke it out and see who's going to win and who's going to lose. And in most of these cases, especially on trust contest cases, trial is going to be winner takes all. And so in most cases, if you've been disinherited, you're either going to win and get something out of this trust, or you're going to lose and walk away with nothing. And so that's also what drives mediation, by the way, is that, it's high stakes. And so going to trial, it's high stakes poker, and you really have to take that into account. And the interesting thing about trial, especially in this area, is when you go to trial on a trust contest case, first of all, it's always going to be a bench trial. You're going to have that trial in front of a single judge. You do not have the right to a jury, which is unfortunate, but that's the way the system works. These are equitable claims. And with equitable claims, there is no right to a jury like there is with legal claims. So you're going to have a single judge that is going to hear your case. And the one issue with that, judges certainly are very good, but they also have seen the worst of the worst. To some extent, they're kind of jaded. You and I, Stewart, as lawyers are jaded. We've been doing this area of law for a long time, and we've handled trust. We've probably handled north of 1,000 cases of trust contests in our careers, just hundreds and hundreds of trust contest cases that we've handled. And after a while, you kind of get the idea that you're seeing the same story play out over and over and over again. We almost, at this point in our careers, we almost never hear a fact pattern from a client that we have not heard dozens and dozens of times before. So there's no surprises left for us. We've heard it all. And a lot of times people will call us up and say, Stewart, you can't believe what I'm about to tell you. You've never heard something like this. And it's like, and then they proceed to tell you, and you're like, yeah, I've handled at least, 250 cases just like that. So judges are the same. They've heard everything. They've heard the worst of the worst. And so they do tend to be a little bit jaded. They're not going to be as shocked by what happened in your situation as maybe a non-judge would be. And that's really where it's a little bit of a shame that we don't get a jury, because juries would be lay people coming in who would be able to hear this with fresh ears and a fresh mind, but that's just not the way it is. And so you're going into that. The other issue you have with is that, technically speaking, these trials are supposed to be conducted under the evidence code, the rules of the evidence code, just like all trials are supposed to be conducted. But when judges are doing bench trials, some judges, more than others, don't have a problem kind of, making the evidence code a little bit looser than it otherwise would be. And so they're willing to take in evidence that maybe they wouldn't normally with a jury trial. And that can work in your favor, but it can also work against you. And so that's a little bit of a unique thing about doing a bench trial. That's just the way it is. And third, you're really trying to convince just a single person. And I think that's really the hardest part of these cases. That one person listening to your case has their own life experience. They've gone through their own things. They may have gone through an inheritance fight on their own in their past. Who knows? But all of those experiences are going to come to play when they sit down to decide your case. And so one judicial officer could hear your case and say, I think you should win, and three others could hear it and say, I think you should lose. Who knows? It's truly a toss-up. And so people who think that they have a slam dunk case, when they come through and they tell us, I've got a slam dunk case, this is guaranteed to win at trial, our response to that is, you clearly have not been to trial very often, and probably not at all, because trial is truly chaos in a lot of ways. But if you're not going to settle your case, you are going to go to trial. And that's where a court or a judge will make a forced decision. You don't have a say in it. The judge is going to rule for you, and it's probably going to be winner take all. So it's kind of the rough and tumble part of this whole process is the trial part. And it's not like TV in the movies. Okay, you're not going to go and it's not going to be some dramatic turn of events, or you're suddenly going to have a surprise witness that comes in and somehow wins the day. That's not going to happen. So trials tend to be long, boring, drawn out, and that's just the way it is. So what are your thoughts on trial, Stewart?
Yeah, it's the problem is all the things you said I echo, and I'll just give you two extreme quick examples. Let me say that 80% of the time the judges get it right. And look, judges, they're hardworking. They've got, if you see what judges have to put up with every morning, 20 to 40 calendar items. I mean, that's 20 to 40 cases that they have to preside over for the morning calendar. And then they've got trial after that. And then they've got all these other responsibilities. What judges have to go through and their staff, it's unbelievable. And we do have the greatest justice system in the world, but obviously there's some shortcomings that come with that. And I'll just give two extreme examples. Our partner, Jeff Hall, and I were trying a will contest case a couple of years ago. And in that case, the evidence was so strong in our favor. I would have bet my left arm we were going to win this case, because it came out at trial so well. The other side had no evidence whatsoever. They just had conjecture and speculation. That was all they had. And every time they got up, when they were cross-examining witnesses or putting their case on, there was nothing that was true knowledge. There were no documents. They hired an expert that had been found lying under oath, and that he'd been kicked out of certain societies of his discipline. And I guess they didn't look him up. And I cross-examined this guy. It was probably the best cross-examination I've ever done in my entire life. And so collectively, that trial, and by the way, our partner Jeff Hall did a fantastic job on that case as well. I walked away from that case because the judge took it under submission, meaning she would give us a ruling weeks later. I just knew that we won that case because the other side had zero evidence, and we had just knocked it out of the park. And of course, the ruling came down and we lost. I disagree to this day with how that turned out. I think that was a case that the facts were on our side overwhelmingly beyond the preponderance of the evidence. But that just goes to show you that clearly we weren't able to persuade that judge for whatever reason. And it could be, Keith, that maybe Jeff and I weren't as good as we thought we were. That always could be the case. But that was a really difficult one. Still bothers me to this day. I also had a medical malpractice arbitration years ago. Same set of facts in front of an arbitrator, knocked it out of the park, got their experts to agree that there was malpractice, and the arbitrator found in the hospital's way. And it's unfortunate. So those things do happen. Let me say also, there was another case that I was on a few years back. Keith and I were actually on it, and we went to trial, and we had no evidence. And so we did the best job we could tap dancing. And we kept trying to get everybody to settle the case because we just knew this was going to be a horrible outcome for us. And we get done with the case and we both go home with our heads hanging low. And several weeks later, we won. And I'm like, what is this judge doing? Are you kidding me? But those are the outliers. And that's why mediation is so important, in my opinion. Yes, you get less at mediation than if you get a slam dunk at trial, but you get to walk away with something. You get something assured based upon the facts of the case. Both sides have to figure out what they're willing to compromise on. Both sides will compromise. Both sides will be a little unhappy. That's generally the sign of a good mediated settlement. Whereas if you go to trial, even if you win, boy, it's that last 3 months before trial, it's just a Herculean effort. No problem. We're okay doing that. It's just emotionally taxing and tolling on everybody, including the party. So trial, we'll do them. It's a little scary because you don't know which bench officer you're going to get. Somebody might have a pro stance on trust contests. Some might have a pro stance on keeping the estate plan just the way it is, unless there's some overwhelming piece of evidence. And you just don't know who you're going to get. So trial if you must. If the other side will not settle and resolve it, well, you don't have any decision to make. You've got to go to trial. But if you can, try to resolve the case at a mediation or a second mediation. And I just want to summarize then, Keith, where we're at here. I think we've done the anatomy of a trust contest essentially in California. And that is we want to get a copy of the trust, all the copies of the trust, the amendments, the restatements, everything, kind of figure out what we're looking at. We want to do a breakdown of that trust. We want to file a petition in the probate court based on undue influence, lack of capacity, and financial elder abuse. And we want that to be a really pretty petition, really pretty pleaded. We want to make sure it looks good. And then we want to do an outstanding job in discovery, where we spend most of our life in the case doing written discovery and depositions, reviewing documents that we get in through by way of subpoena and so forth. And then we want to go to a mediation and hopefully resolve this case for everybody, including our client, favorably for our client. And then if you can't do that, then you've got to go to trial and you got to give it to a judge, and then the judge is going to make a decision for everybody. That's my understanding of the anatomy of a trust litigated case in California. Does that sound about right, Keith?
Yeah, I think that's a great summation of the whole process from start to finish. And, it's really important to remember that when it comes to trial, great cases can lose and bad cases can win. Anything is possible. And it's kind of you to talk about a couple of cases that, we didn't win, but we also have won many, many cases in our careers as well. And you've won a lot of really big cases in particular, Stewart, but it doesn't mean that every case is going to win. And even if you think it's a great case, it's always a big question mark as to how it's going to come out. But at the end of the day, that's kind of the final step in the process. You go to trial, you'll get your result. And from there, to be honest, your case is really quite done. You can talk about appealing a bad result from a trial, but there's a lot of problems with that. And there's a lot of times when appeal simply isn't going to work. And I think that kind of goes beyond the subject of this video here. And we can do other videos about appealing, but for most people, the result you get at trial, if you go that far, is going to be what you're going to live with in terms of this case. And so mediation is very important for that reason, because settlements can be fantastic. And there's an old saying in the law that a good settlement is better than a great trial. And so it really does come down to that.
The Big Challenge is presented by Albertson Davidson, LLP. We're ready to handle any big challenge. Albertson Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for hundreds of legal articles and videos to answer all your California trust questions. We'll see you on the next episode of The Big Challenge.